You know when you're driving in a new, unfamiliar place and your GPS confidently tells you to turn right?
Yeah, and you just make the turn because, well, you inherently trust the system that's always worked for you.
Exactly. But then you suddenly find yourself staring at a solid brick wall. Or, worse, your tires are just sinking straight into a lake.
Right, because the map said one thing, but the reality on the ground was, well, it was completely different.
And that is the exact scenario playing out for just countless foreign businesses. When
Hmm.
they try to navigate the commercial landscape of Vietnam, they bring their standard practices, plug them into the local market, and just drive their investments straight into a legal lake.
Yeah, because the navigation system they brought with them was built for a different terrain entirely. The invisible infrastructure underneath them just doesn't match the code.
So, welcome to this deep dive. Our mission today is to equip you with a survival map for the hidden legal landmines of doing business in Vietnam.
Whether you're an entrepreneur looking to expand, an institutional investor putting down capital, or just intensely curious about international commerce, this is for you.
Right, we're going to dissect a massive stack of intelligence today. We've pulled together comprehensive guidelines from international chambers of commerce, postmortems on construction and commercial leases from local legal analysts, and some really crucial updates on consumer protection.
And the goal here is to show you how seemingly harmless business assumptions, things you do every day, can trigger catastrophic blunders.
Because, as you were saying earlier, the fundamental error most businesses make is assuming the truest test of an investment happens during, like, the enthusiastic handshake.
Or the ribbon-cutting ceremony,
Ah,
right? Yeah. But the truest test is the fine print of the contract when a dispute inevitably arises.
which is when the actual reality of the local legal landscape asserts itself, right? It
Right.
just strips away all those polite assumptions.
Exactly. And that brings us to the first fatal mistake, which usually happens before ground is even broken.
Okay, let's unpack this. We're talking about the drafting table, right? The copy-paste catastrophe.
Yes. A foreign business comes in, they download a standard international contract template, or they take the boilerplate they've successfully used in London or New York.
And they just swap out the company names and assume it works in Vietnam. I mean, it reminds me of bringing a high-end 110-volt appliance from the US, plugging it directly into a 220-volt socket in Hanoi without an adapter, and acting shocked when it catches fire.
That is the perfect analogy. The underlying current simply operates on a different frequency there. A contract can look entirely proper on the surface,
Right. It's got the signatures, the official company seals.
pages and pages of standard indemnification language. But practically, local legal briefings warn that these imported templates often lack any real enforceability.
Just because they rely on Western legal traditions that don't apply.
Precisely. For instance, a foreign company might draft a contract outlining delivery obligations based on an assumption of implied good faith, or maybe industry standard commercial reasonableness.
Which works in Western jurisdictions, right? Courts there will just fill in the gaps of a vague contract using those implied concepts.
Right, but chambers of commerce operating in Vietnam explicitly warn investors against this. You cannot assume that local counterparts or local courts share your specific concepts of fairness.
So if a contract fails to include hyper-specific mechanical quality inspection procedures, it's useless.
Basically, yes. Or if it relies on vague penalty clauses, it is essentially unenforceable. You never compensate a partner for a promise.
Wow. Okay.
You construct the contract so you only compensate for provable, documented performance.
I get the theoretical risk of being vague, but in reality, aren't multinational companies insulated from this if they just use standard arbitration clauses?
You'd think so, but no.
Because surely, if both sophisticated parties sit down, agree to the terms, and sign the document, a deal is a deal, right? The binding nature should supersede subjective fairness.
What's fascinating here is the massive gap between legal validity and practical enforceability. Under Vietnamese law, a signed lawful contract is absolutely binding.
Okay, so it is valid.
Valid, yes. But having a valid contract just gives you the right to stand in a courtroom and argue. If your clauses rely on Western assumptions rather than explicit localized mechanisms, you aren't getting a swift summary judgment.
Oh, I see. So you're just buying yourself a ticket to spend months or even years in court.
Exactly. You're trying to mathematically prove your damages to a judge who requires strict documentary evidence for every single claim. An unclear copy-pasted clause doesn't just cause a minor headache.
It initiates a prolonged legal nightmare that drains your operating capital.
Yeah, it really does.
So the content of a copy-pasted contract is clearly a trap. But since we just established that, let's look at the actual mechanics of executing these everyday agreements.
Right, the physical signing process.
Because there is a massive amount of mythology surrounding the famous Vietnamese company Seal the Red Stamp.
Oh, absolutely. The red stamp is perhaps the most misunderstood element of Vietnamese corporate law by foreign investors.
People treat this thing like it's a wax seal on a medieval royal decree.
They really do.
There is this pervasive assumption that without that physical red stamp, the document is worthless. And as long as it has the stamp, it's an ironclad guarantee.
Well, historically, that assumption was grounded in reality. The stamp was a strict tool of state administrative control. But the legal infrastructure has shifted significantly toward corporate autonomy.
So a contract lacking a red seal is not automatically void anymore?
Not at all. The legal pivot focuses almost entirely on the authority of the signatory.
Okay, so it's about the person holding the pen, not the ink on the paper.
Yes, exactly. If the individual signing the document has the explicit documented legal authority to bind the company, usually the designated legal representative, then an email, a scanned PDF, or a digital signature can be fully binding.
That's a huge shift.
It is. But where businesses get severely burned is relying on the reverse assumption. You could have a beautifully formatted physical contract completely covered in official red stamps from your supplier.
Right.
But if it was signed by an unauthorized middle manager or a regional sales director who didn't possess the legal right to represent the parent company, that fully stamped document is completely useless.
Wait, really? So the parent company can simply disavow the agreement?
Yep, leaving you totally exposed.
That completely flips the traditional assumption on its head. And this plays out in routine, everyday business operations, like securing commercial real estate, right?
Oh, everyday renting is an absolute minefield.
Yeah, local law firm postmortems on commercial leases highlight these incredibly common, seemingly harmless clauses that consistently cost businesses massive amounts of capital.
The structural traps embedded in standard commercial lease deposits are a perfect example of this.
Let's talk about the narrow purpose trap. This one is crazy. You sign a lease, and the stated purpose in the contract is operating a cafe.
Right, and pretty standard.
But then, 6 months in, your business model evolves slightly, and you start selling some retail coffee beans and prepackaged snacks.
And the landlord suddenly evicts you.
Exactly. They want to lease the space to someone else for a higher rate, so they evict you and confiscate your entire deposit because you technically violated the narrow purpose of the agreement.
It's ruthless.
Yeah.
And then there's the deposit versus holding fee trap.
Oh, yeah, where you pay a substantial sum to reserve a prime retail spot. But the deal ultimately falls through because the landlord's building completely fails a local fire safety inspection.
But because of how the initial receipt was phrased, the landlord legally retains your money as a non-refundable holding fee.
Despite being entirely at fault, it's wild.
And we can't forget the subjective nature of property handover. That's another classic vulnerability.
Right, returning the space in its original condition. If a business owner didn't conduct a forensic, mathematically documented handover inventory with photographic evidence on day one, that phrase becomes a weapon.
The landlord can point to standard wear and tear or just a minor scratch on a fixture and use it as legal justification to refuse the return of a 6-month deposit.
And if you look at the financial architecture of a business, you see why this is so devastating to the listener. A commercial lease deposit in Vietnam is rarely just 1 month's rent.
No, it could be 3, 6, or even 12 months of capital locked away.
Right, so it isn't just a polite promise. It is core working capital. Losing that liquidity can instantly cripple a medium-sized enterprise.
A single semantic error in a lease agreement ends up costing exponentially more than retaining a local legal advisor to surgically restructure the document up front.
It's the definition of penny-wise and pound-foolish. So we've seen how ambiguity destroys a business in a simple cafe lease. But let's scale this up.
Let's do it.
Because if a simple lease is riddled with traps, what happens when we move into multi-million-dollar infrastructure and construction projects? The ambiguity doesn't just scale, it becomes weaponized.
The risk profile changes entirely when you introduce complex supply chains and massive capital outlays. Legal analyses of construction disputes highlight a few specific clauses that constantly ruin foreign contractors.
The reasonably inferable clause really stands out in the sources.
Oh, that one is brutal.
This mechanism basically dictates that the contractor is financially responsible for building elements that aren't even included in the architect's blueprints, as long as those elements can be reasonably inferred to be necessary.
Yeah.
I mean, it's like hiring a master chef to bake a wedding cake, intentionally omitting flour from the recipe you provide them, and then suing the chef when the cake collapses.
Claiming it's reasonably inferable that a functioning cake requires flour.
Right. Exactly.
Yeah.
Contractors are routinely forced to absorb devastating financial overruns to fix incomplete client designs.
It's a predatory shifting of design liability onto the execution team. And the structural disadvantages continue with clauses like no damages for delay.
Which actively strips contractors of their right to claim any financial compensation for project delays?
Yes, even delays that are entirely dictated by the owner, like failing to secure zoning permits or not providing physical site access on time.
Wow. And then there's the aggressive misuse of indemnify, defend, and hold harmless clauses.
Right, those are drafted to force a secondary subcontractor to absorb all third-party liability. It effectively shields the developer, even if the developer's own negligence contributed to the incident.
Here's where it gets really interesting, though. Let's look at the flip side of this. Let's say your partner is the one who breaches the contract. They delay the project. They deliver substandard materials. How do you punish them?
Well, Western businesses fall into a massive structural trap when they try to enforce penalties. This is one of the most critical foundational differences in Vietnamese contract law.
Okay, break that down for us.
In common law systems, parties can negotiate and pre-agree on a fixed, punitive amount of damages to be paid automatically if a breach occurs. These are known as liquidated damages.
Right. It creates immediate financial certainty and acts as a strong deterrent.
Exactly. However, under Vietnamese civil law, the absolute core principle is that damage compensation must strictly equal actual, direct, and proven losses.
Wait, so you can't just invent an intimidating number to keep them in line?
You absolutely cannot. Legal scholars often point to a landmark Supreme Court case from 1997 that crystallized this principle.
Okay, what happened in 1997?
A trainee signed a contract with a labor export company to work in Japan. The contract explicitly stated that if she abandoned her post, she would owe a minimum of 2.5 million Japanese yen in compensation.
Okay. And did she run away?
She did, and the company took her to court demanding that exact pre-agreed amount.
I mean, in a Western court, if she signed the document, that's generally an open and shut breach of contract case.
But the Supreme Court invalidated that specific clause. They ruled that the pre-agreed 2.5 million yen was arbitrary. It was not a reflection of the company's actual proven physical or financial damage.
Oh, wow. So because the company could not produce strict accounting evidence that their direct losses equaled exactly that amount, the punitive damage clause was thrown out?
Thrown out entirely.
So all these foreign multinationals writing things like, if you delay this factory build, you automatically owe us $5 million, they're essentially writing legal fiction.
It is entirely unenforceable as a damage claim. To navigate this, businesses have to explicitly structure these clauses as penalties for breach rather than damage compensation.
But that introduces a massive statutory limitation, doesn't it?
It does. Commercial penalties are legally capped.
Strictly capped.
Very strictly. For general commercial contracts, the penalty cannot exceed 8% of the specific value of the breached obligation.
Wait, only 8%?
Just 8%. For construction contracts, the ceiling is slightly higher at 12%. But you cannot use the threat of unlimited financial ruin to terrorize a partner into compliance.
If you are an investor listening to this, that 8% cap completely alters your negotiation leverage on Monday morning.
Oh, fundamentally.
I mean, if the specific obligation your partner breached is valued at $100,000, your absolute maximum commercial penalty is $8,000.
Right. And for a bad contractor, eating an $8,000 penalty might just be calculated as the acceptable cost of doing business while they prioritize a more lucrative project elsewhere.
Which is why relying on punitive contract clauses as your primary defense is a failing strategy.
Completely failing.
So we've been analyzing the blast radius of a bad contract heavily on the B2B side, but what happens when you expose that same level of legal ambiguity to thousands of everyday consumers?
The risk profile mutates completely. The B2C landscape is shifting aggressively, introducing heavy compliance burdens.
Yeah, the new law on protection of consumers' rights, which took effect in July 2024, is a massive overhaul.
It really is. The law was engineered to address the explosive, somewhat unregulated growth of e-commerce and digital services in Vietnam. It forces foreign companies to fundamentally re-architect how they interact with users.
And the mechanisms of this new law are incredibly specific. Take influencer marketing, for example.
Well, that's a big one.
It is now strictly prohibited to obscure influencer sponsorships. If a brand compensates an individual to promote a product, that financial relationship must be explicitly and publicly disclosed to the consumer.
And furthermore, the days of the standard Western click-wrap agreement are over.
Right. You can no longer force a consumer to opt in to broad data collection as a mandatory, non-negotiable condition just to access a basic platform or service.
That data protection rule effectively breaks the standard user acquisition funnel many foreign tech companies rely on. But the most operationally severe update is the new product recall regime.
They've instituted a strict two-tier system based on the severity of the defect, haven't they?
Yes. Category A recalls involve products that pose any potential threat to life or health. The compliance mechanism here requires companies to execute massive public media announcements across multiple consecutive days, broadcasted widely.
Think about how a mandatory Category A recall impacts a brand. Having to legally self-report a health risk through a multi-day public media blitz. I mean, that will instantly tank a company's search engine optimization, destroy their public goodwill, and severely impact stock valuation.
It really forces companies to push their quality control investments way upstream, long before the product ever hits the market.
And what about Category B?
Category B recalls, which only involve a threat to property, have a lower threshold. They require announcements primarily on the company's local digital properties or physical storefronts.
Still a headache, but not a public media blitz. The law also mandates enhanced systemic protections for vulnerable demographics too, right?
Yes, specifically requiring tailored service models for the elderly, the disabled, ethnic minorities, and pregnant or nursing women. The operational overhead to ensure compliance across all these new consumer touchpoints is just massive.
And while a business is busy trying to manage all of this complex compliance, they also have to defend against out-and-out fraud,
Which is rampant.
Recent local commercial forums released a startling statistic. A staggering 52% of Vietnamese businesses have reported experiencing some form of international trade fraud.
52%. That raises an important question. If the regulatory environment is this complex, if the penalty caps neuter your leverage, and if trade fraud is that prevalent, how does a business actually survive and protect its capital?
Because relying purely on the meticulously drafted text of a contract is demonstrably insufficient. The contract is just paper. It doesn't physically stop someone from disappearing with a wire transfer.
Exactly. Survival requires a fundamental behavioral shift in how business is conducted.
So what does that look like in practice?
It means allocating real capital toward exhaustive, on-the-ground due diligence before any agreements are drafted. It means utilizing secure international standard payment mechanisms like letters of credit rather than just wiring massive upfront deposits based on a pro forma invoice.
Right, changing the actual habits.
And crucially, it requires companies to unite within localized industry associations. Sharing intelligence about fraudulent suppliers or bad actors prevents those entities from scamming multiple companies and undercutting the broader market.
Okay, so let's play out the absolute best-case scenario. Let's say a business listens to all this advice. They conduct extreme due diligence.
They do everything right.
Right. They hire top-tier local legal counsel to translate their copy-pasted templates into enforceable local frameworks. They verify the signatory's authority, sidestep the lease traps, carefully structure their 8% penalties, and perfectly comply with every mandate of the 2024 consumer law.
Flawless execution.
Flawless.
Yeah.
But despite all of this, the local partner still blatantly breaches the contract. The foreign company takes them to court or arbitration, and they win.
Yeah.
They are holding a legal judgment in their hand, ordering the partner to pay them back. The system worked. They're safe, right?
Unfortunately, no.
Yeah, really?
The most sobering reality detailed in these legal postmortems is this. The greatest financial risk in Vietnam is not losing a commercial lawsuit. The greatest risk is spending years and hundreds of thousands of dollars on legal fees to decisively win a lawsuit, only to discover that you cannot recover a single dime.
Because securing the judgment and actually executing the collection are two completely isolated, decoupled processes.
They are entirely different battlegrounds. The enforcement of a civil judgment is a grueling, opaque process. You might secure a brilliant legal victory, but by the time the enforcement agencies attempt to seize the assets, the landscape has changed.
The breaching company might technically still maintain an active business license, but physically possess zero liquid assets.
Exactly. They may have quietly ceased physical operations months prior.
Or they engage in asset siphoning. The executives see the lawsuit trending poorly, so they quietly transfer their intellectual property, their client lists, and their cash flow into a brand new corporate entity registered under a relative's name.
Leaving the original company as an empty, bankrupt shell by the time the court tries to collect. The judgment is valid, but the target is a ghost.
Okay, but if I'm a massive multinational corporation, why would I ever subject myself to local enforcement uncertainties?
What do you mean?
Well, why wouldn't I just dictate in the contract that any and all disputes must be resolved in my home country's courts? Or maybe at an international arbitration center in Singapore, just entirely bypass the local jurisdiction?
You can attempt to structure the agreement that way, but legal briefs heavily caution that foreign arbitration is not the silver bullet investors think it is.
Why not?
While the law generally grants parties the freedom to select foreign law or foreign arbitration for standard cross-border commercial disputes, there are absolute non-negotiable exceptions.
Like what?
If your dispute involves real estate located in Vietnam, labor contracts with Vietnamese employees, or consumer contracts signed in Vietnam, the dispute absolutely must default to Vietnamese law and local jurisdiction.
Ah, so you cannot contractually maneuver your way out of the country's sovereign jurisdiction on those foundational issues.
You cannot. Furthermore, even if your dispute qualifies as purely commercial and you go to Singapore and you win a massive binding arbitration award, what is the next step?
I guess you have to collect.
Right. If the breaching company's assets, their factories, their bank accounts, their equipment, are located inside Vietnam, you still have to bring that Singaporean award back to a Vietnamese court to have it recognized and enforced locally.
Oh, wow. And I'm guessing that's not easy.
The legal procedure to recognize a foreign arbitral award locally is heavily scrutinized, highly complex, and notorious for being incredibly time-consuming.
So what does this all mean? We've laid out a pretty intense minefield here. If contracts are riddled with semantic traps, if financial penalties are strictly capped at 8%, and if spending years to win a definitive court victory still leaves you empty-handed because the assets vanished, what is the functional point of signing the contract at all?
The point is recognizing a total paradigm shift. You cannot view a contract in Vietnam merely as a weapon to deploy in a courtroom to win a lawsuit.
Right.
In this jurisdiction, the moment you are forced to file a lawsuit, you have already lost the economic battle. The contract must be structurally designed as a tactical mechanism to prevent the dispute from ever materializing.
And you achieve that through structural leverage, not threats of litigation.
Exactly. You engineer the deal using tight milestone payments, ensuring you never extend a volume of capital that you cannot afford to lose. You utilize independent holding funds. You require performance bonds from local banks.
So the ultimate objective of the contract is to design a financial architecture where it is mathematically and economically irrational for the counterpart to breach the agreement in the first place.
Yes. Investing heavily in prevention, background checks, and structural leverage up front is infinitely cheaper than attempting to litigate a cure.
Wow. Let's pull all of these threads together. We've navigated a complex survival map today. We dismantled the outdated illusion of the red stamp, establishing that documented legal authority is what actually binds a company.
Right.
We exposed the semantic booby traps hiding in everyday commercial leases and the predatory risk shifting in major construction agreements. We highlighted the critical difference between Western liquidated damages and the strict 8% commercial penalty caps.
Which completely alter negotiation leverage.
Absolutely. We explored the heavy new compliance mechanisms of the 2024 consumer protection laws, from influencer transparency to the brand-destroying reality of Category A public recalls. And finally, we faced the harsh truth that a victorious court judgment is functionally useless if the local enforcement mechanisms fail to recover the assets.
It is an intricate, highly localized ecosystem. It is highly profitable for those who navigate it with respect for the actual terrain, but punishing for those who rely on imported, unverified assumptions.
And as we look at this entire landscape, where written contracts are constrained by rigid penalty caps, subjective interpretations of actual damage, and the absolute nightmare of post-judgment enforcement, it raises a fascinating final thought for you to consider.
It really does.
We asked earlier what actually holds a deal together if the paper fails. In a legal environment this complex, perhaps the true security of an investment doesn't lie in the paperwork or the arbitration clauses at all.
Right.
It begs the question, is the deeply rooted Vietnamese cultural concept of quana, the continuous long-term building of social capital, mutual reliance, and deep personal relationships. Actually, a far more binding, protective, and enforceable force than any legal clause your lawyers could ever draft.
The social capital is often the only thing ensuring the legal capital is respected.
A completely different type of currency. Well, thank you for joining us on this deep dive. If you are operating internationally, we highly encourage you to pull your standard contracts out of the filing cabinet tomorrow morning and review them through a highly skeptical, localized lens. Because, as we've learned, just because your GPS insists the road is clear doesn't mean you aren't about to drive straight off the cliff. Until next time.